Bassett is the president of Bassett IP Strategies and has been patent agent registered to practice before the U.S. PTO, which stands for Patent and Trademark Office, since 2004. Prior to starting Bassett, Dave received his BS from Clarkson in '88 and his MS from University of Houston in '91. He worked as a chemical engineer for 14 years. During that time, Dave received his MBA from the Simon School, where he earned the 2004 Whitney Award as Outstanding Student. Dave has a broad background and is familiar with a wide range of businesses, from manufacturing and contract packaging to environmental, chemical, plastics, oil and gas, biomedical, optics, and microelectronics. Among other groups, Dave is a member of the American Intellectual Property Law Association, the National Association of Patent Practitioners, and is the current Vice President of RPCN. David, welcome, and we're looking forward to the presentation.
Thank you very much, Mike. As Mike said, I'm Dave Bassett, President of Bassett IP Strategies, and today I'm here to talk about how the patent system's changed under the American Invents Act, which passed in 2011. We'll talk about how to get your invention patented and how you can protect your invention. I'm not a lawyer, but I play one on TV. So we got the disclaimer there. Basically, all the material that we're going to cover today, it's public information intended solely for educational purposes to help people here understand U.S. patent law. Material covered isn't legal advice, reflects the views of the presenter, law. While every attempt is made to ensure that the material covered is accurate, there may be errors or omissions for which liability is disclaimed. With that out of the way, as I mentioned, I'm a patent agent, very similar to a patent attorney for doing work directly with the U.S. Patent Office. I can help you get patents issued. What I can't do is I can't help you if a third party gets involved. If there's an interference or if you're looking to get your invention licensed to somebody, I can help you file the papers. I can't draw up the agreements for you. Today we're going to cover a few items. First off, we'll go over some patent basics. I know a few of you in this room have a pretty good understanding of the patent system and the process. I apologize if anything we go over ends up being a little too basic, but we've got a wide range of experience here in the room. We'll also talk about the Ladies Smith Act, the American Invents Act. We'll talk about how the patent system works under the new law. We'll talk briefly about how the patent system worked under the old law. Talk about what it all means to you and your ability to get something patented. And we'll go over some final thoughts. I'm going to try to take questions as they come up. If we start running short on time, then I'll ask that we hold off on questions to the end of the talk. So we're patent basics. First off, what is a patent? Well, a patent is an item that allows an intangible item, your idea, to have a tangible transferable value. The patent allows you to get your idea out into public and keep people from being able to steal it. Without having patents around, you really wouldn't have a way to keep other people from using your idea. The patent gives the owner of an invention the right to exclude others from making, using, or selling their invention. Notice I said it gives you the right to exclude others. It doesn't necessarily give you the right to make or use your patent. And what I mean by that is, it's possible that you've made an improvement over what somebody else did. Let's say for a moment that you invented a keyless remote control for a car. Hey, cool, I've got something that I'm going to be able to make a whole lot of money with. Everybody's going to want them for their luxury cars, maybe mid-size. Who knows? Eventually, we'll get to a point where maybe all cars will have something like this. I'm going to get a patent on it, get it protected, and I'm just going to go to town with it. Well, a slight problem in that you've come up with a keyless car remote control, but there already was a car remote control for opening the doors and that. Yours is an advancement over the other, so the person that would have the patent on the original remote control, they'd be able to keep you from doing your invention, but you could work out a license agreement or something with them. And what you also could do is, although they had the original remote control, they wouldn't be able to do the keyless version without your permission, if everything's patented and working. Essentially, your patent gives you, the inventor, a limited monopoly on your invention. Gives you the right to exclude others for 20 years, and what you do in return is you tell the world how to make and use your invention. It's so important, according to our founding fathers, that it's actually covered in the Constitution. Under Article 1, Section 8, Clause 8 of the U.S. Constitution, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So, even back then, our founding fathers saw that there's a pretty good value to letting people own their ideas. Talk about a patentee's term. We're not going to cover a whole lot of patentees during this talk, but one that you will end up hearing from your attorney or your agent. You'd hear it from the patent office, anybody talking about patents. They'll talk about enablement. Now, what's meant by enablement? Does it mean that you're going to teach your patent how to do the work that it does? Kinda. You're going to teach it how to dance? You're going to teach it how to play the guitar? No. Are you going to teach it how to talk? That actually you are going to do. You're going to teach your patent, in order to get to a point where it can be issued, is going to need to describe your invention and the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to make and use the same. Doesn't have to be the world's greatest expert in the field that you're teaching how to use that invention, just someone that's in the field, knows the principles involved in what's going on. They would be able to make and use it. Don't have to teach some kid in college how to do it, but somebody that knows the subject, you will have to get up to speed. And what is patentable? Well, any process, machine, manufacture, or composition of matter or improvement thereof. That's pretty cool. Come up with a process or a machine. Anyone is patentable. That should be pretty easy, right? Provided. Dog it. There's always a catch, right? Well, there's a catch here too. It's provided that it's new, it's useful, and it's non-obvious. By new, just mean nobody else has come up with it. Not to get too circular here, but in order for you to have an invention, you have to have invented something. There must be an inventive step to it. It must be useful. And by useful, we don't mean to the user necessarily or to the inventor. We mean in general to society. Somebody could come up with a great new way to break into homes, make it a little easier to get the loot out. If you described it that way in your application, you wouldn't be able to get a patent on it because it's not really useful to society. Of course, that's a pretty easy thing to get around the useful, in that somebody that did come up with something like that, rather than describe it as a way to rob the house, you might describe it as a way to get into the house quicker if you heard an old lady shouting out, kind of like in the old commercials, "Help me, I've fallen, I can't get up." Hey, I've got a better way to get into the house, we can do it a little quicker, rescue workers can get in, the firemen can get in without breaking the door down. Most items that you can invent, you'd find a way to make them useful. Not that I'm condoning breaking into houses. And they also have to be non-obvious. If this were a light pointer, a pen-style light pointer, well, you could have one where it clicks on like a pen. You could have it where it clicks on this way. Well, hey, I've seen pens before. I've seen laser pens. I'm going to come up with like a laser pencil, where it turns kind of like a mechanical pencil. Because the laser pointer is already out there, the pen's out there, the pencil, just coming up with just twisting it as a new way to turn it on probably would be considered obvious. And again, it's something that would be non-obvious to somebody of ordinary skill in the art. You don't have to come up with something to be patentable. You don't have to come up with something that an Einstein would have been able to figure out. Or actually, that Einstein would have been able to figure out. You just have to come up with something that somebody ordinary skill in the art would have come up with. Any questions? Yes, sir.
Those terms seem fairly subjective to me, whether it's useful or non-obvious. Who makes the determination whether it's
The person that will make the determination whether it's non-obvious is the patent examiner with the Patent and Trademark Office. When you submit your patent application, they will examine it. And we'll talk about the process in a little more detail shortly, but they'll review your patent application and determine whether there's prior art that exists out there that you read on. If you do, they'll say that, well, your invention isn't novel. If they see a couple of different inventions out there that are similar to yours, that they feel that yours is a combination of, and they think that it would be relatively directly identifiable, that somebody would have come up putting these two inventions together, they'd say that, well, your invention is obvious, reading this patent in light of this other patent. So that comes down to the patent examiner. And then, like I said, we'll get into a little more detail shortly, but you can come back and make a response back to that initial office action, explain why, in fact, your invention wouldn't be obvious. So you're right, the terms are a little subjective, but again, it's in the eyes of the patent examiner, they're examining your application in regards to the art that's out there and the skill level of the people that are involved in that field. Patent basics, well, another one, what are the categories of patents? Well, within the US system, you've got a few different categories. The first one is the utility patent. And this is what most people think of when they think of a patent, when they think of an invention. It covers the utility, the use of a particular item. If I had a patent on this pen, it'd be how to make the pen, how to use it. Might be covering the method of using the pen. Say I've got it, use this pen as a fishing lure. Not obvious. The pen's been around for a long time. You come up with a way to make it a fishing lure, and actually catch fish with it. Not necessarily obvious. In your application, you'd explain how to make it, how to use it, and you could get possibly get a patent on it. That patent would have a 20-year lifespan from the date that you filed your application. There's also what they call a plant patent. By plant patent, are you referring to the power plant? And sadly, no, my 13-year-old didn't draw that. No, actually, we're not referring to a power plant. We're referring to an actual plant. Any plant that's asexually reproducing, non-tuber, cultivated plant, you can get a patent on if you develop a new species or new variety. They have to be able to be asexually reproducing, so you have to be able to take like a cutting off it and get new plants coming up. And they can't be tubers. So you are not allowed to get a patent on a potato. If you take nothing else from this talk, you know you cannot patent a potato. The reason for that is apparently potatoes and other tubers, they can reproduce just from the roots, and somehow, I guess, I'm not an expert on the plants, but I guess that somehow their DNA can change slightly, so you're not necessarily having the exact same plant coming through. So that's why you can't do plants. There's also what they call a design patent. Design patent, you notice it's got a different lifespan than the others. Lasts for 14 years from when the patent issues, and unlike a utility or a plant patent, which cover the use of the invention, the design patent just covers the way it looks. If I put special wiggly lines on the shirt clip here on the pen, you know, maybe I could get a patent on that. The best example that I have comes from the world of football. Anybody watch the Sunday football games? Remember a few years back, Southwest and a couple other of the beer advertisers had commercials on where they're kind of making fun of referees. You know, they got referees that like to go around and steal beer. They've got Southwest even was crazy enough to have one where a referee can't get a coin toss right. Like that would ever happen. Don't like it. But the NFL was not happy with these ads. They showed just guys in striped shirts, referees. You assume they're NFL referees because they're being broadcast during the NFL games. NFL thought they were NFL referees. Went to their partners and said, hey guys, we'd really appreciate it if you'd stop showing these ads. And the advertiser, you know, we'd love to stop, but these things are testing through the roof. The Q rating on these is just absolutely insanely high. We can't get rid of these. So the NFL thought, okay, they're not going to stop doing this. And they pay us a lot of money to put their ads on. So we can't force them to stop running these ads. How can we get our referees out of these ads? Well, the way they did it is, I don't know if you noticed, probably about like 5-6 years ago, actually about a year or two after those ads started coming out, the NFL referees' uniforms changed. Their shirts now, the stripes, they kind of like get wider and narrow back down. They got funky pants. Their caps are a little unique. And with the NFL, and about the time that happened, stop seeing the Southwest ads. What happened is the NFL got design patent on their referees' uniforms. NHL also changed their referee uniforms around too. So I don't know if maybe they were having some issues up in Canada with the same same sort of stuff. See some guy in skates running around in a striped shirt stealing beer or something. But they got their design padded, and the ad stopped. My guess is probably in about like another 3 or 4 years, you're going to see referee uniforms in NFL change again. Either that, or you're going to see those TV commercials come back. Because when the patent expires on the design patent, they'll need to change them around again.